wanted to begin by noting that in 2010, it's a lawyer at Wiley Ryan who put together a PowerPoint presentation intended for brand drug companies. And I will be including that in the record for today's hearing. Now, this begins with the caption that reads, REMS as a tool for profitability. Here's another great one that I thought you might enjoy. It says, it's got this great graphic here. It says, Dr. Strange REMS, how to learn to stop worrying and love REMS. First time those words have been uttered, I think, in the English language when this was written. The presentation goes on to describe how REMS is not just, quote, full of oppressively burdensome requirements, close quote, but can instead be helpful for, quote, life cycle management. Later in the presentation, after explaining how REMS programs can be used to get around FDA regulations regarding pharmaceutical advertising and direct-to-physician marketing, it turns to the competitive impact of REMS, questioning whether brands are really prohibited from using them to stop competition, and in any event, whether there's really any enforcement mechanism against doing so, against using them for blatantly anti-competitive reasons. So my question to you, and I'll throw it out to each member of this panel, anyone who wants to answer it. In light of this, why should complaints raised by the brand companies about the CREATES Act be taken at face value? I mean, if this is how branded pharmaceutical companies are approaching this, if in fact they view this as an appropriate way, as a great opportunity to engage in what we would otherwise consider blatantly anti-competitive behavior, why should we take seriously their complaints with the legislation? Ms. Zelnikoff, I was wondering if we could start with you on that.
Thank you very much, Senator Lee. I echo your question. I don't know. I think we have to always take seriously everyone within our economy and our sphere. But in this case, the CREATES Act is critically important. It's important for patient safety. It should not be a tool for anti-competitive behavior. And the presentation alone lets us know that we have to go forward and take it seriously. I think brand has to establish much more rigorously why their issues are serious in light of that type of presentation.
Mr. Safar, do you want to respond to that?
Yes, I mean, first of all, we don't know whether those plans were adopted. It looked more like a selling tool for a law firm than anything else. But I think the critical thing and a critical, I think, deficiency that we see or that I see in the Act really relates to those products that have both the REMS with the ATASU attached, the ones where there are really restrictive provisions to protect the safety of patients. And here, what this bill does, it doesn't say, FDA, you approve what the generic is going to do. It says, the generic, you come in with a protocol that looks kind of like what the Pioneer has set up, and if you do that, we shall authorize it. There's no approval process here, and that's one of the things that concerns us.
Before you go on, I want to drill down on something you said a minute ago that it may well have been more of a selling point for some lawyers marketing their services within a law firm to certain players within the pharmaceutical industry. Do you not agree, though, that REMS programs could be manipulated that way, that the regulatory framework surrounding REMS programs could be used in the way that is described?
I think REMS programs can, yes, of course it's possible that a REMS program could be set up as an artificial roadblock, but at least the industry, by an individual company, but the industry and the Pharma Trade Association doesn't take that position. We believe that some kind of bill like this might be passed, or certainly I believe that some kind of bill like this might be passed with additional protections, such as instead of saying comparable, it would be equivalent. There's no reason why you can't have similar kinds of, or very, equivalent protections for patients. There's also in this bill no provision for indemnification of the company who is be forced to hand over their drug and then possibly mishandled by a generic in terms of the way they test it. We would like to see IND-type controls so that the FDA has some authority later on.
There is, in fact, a liability provision within the bill. Are you saying it's inadequate?
The liability provision relates to, there's a violation of the Food and Drug Act, under the Food and Drug Act itself, that says if you distribute a product outside of the REMS, that is either, I believe it's a misbranding, it's a criminal violation. What this bill says is the authorization, the letter that FDA gives to the generic says, we won't view this as a violation. It doesn't amend the Food and Drug Act. That violation remains in the Food and Drug Act. It basically says, we, FDA, won't enforce.
Yeah. So you're talking about, if we turn to page 24, starting at line 23, a license holder shall not be liable for any claim arising out of the failure of an eligible product developer.
That's what the authorization will say.
Right.
And the question is whether that conflicts with the current language in the Food and Drug Act, which says anything that goes outside of the REMS is a violation.
Yeah, I'm sorry. I'm having a real problem with your approach to statutory construction on this, and my time's expired on this round. I want to get to others, but Professor Feldman wants to respond. I can sense it.
Yeah, thank you. There's a basic canon of construction that says when Congress speaks, it intends to make sense. It would make no sense to have a bill that says one is authorized to transfer and then for the government to go after the person who transferred. If the government were to do that, which it would not, it would be dismissed by a judge in a heartbeat.
I tend to agree. And look, I understand I'm a politician. People assume, perhaps correctly at times, that politicians don't read. But as a recovering lawyer myself, I can say, as I look at this, I cannot fathom a canon of statutory construction. I cannot fathom an instance in which an Article III court could read the legislation in the manner that you're describing. I don't see it.
May I answer? I'm sorry.
Sure.
I'm not saying that the government would go and prosecute under that. It is a get-out-of-jail-free card, so to speak. But the language remains in the Food and Drug Act. We would think that if you're going to be amending, in effect, the REMS program, the entire program, it seemed very odd to us that there's no change at all in the Federal Food and Drug Act. None of these provisions amend the Food and Drug Act, which would be seen to be the logical place that this would go.
Okay, I understand your point. This is rather different than the point you were making earlier. The point you were making earlier was to the effect that there's no indemnification, that there's not protection from liability.
No, I'm sorry. Excuse me. I'm sorry. When I said indemnification, I wasn't talking about the liability. I was talking about there's no indemnification from product liability cases that might result from handing the drug over to a generic company that then either misuses it or uses it outside the REMS. There's an injury. There, what's going to happen is that the pioneer is going to be sued, not the generic.
Okay, all right, we'll pick this up later. I'm over time. We'll go to Senator Klobuchar.